Happy Valentine's Day, everyone. I know you all dreamed of this, that on Valentine's Day you'd be sitting in a room in the House of Commons. Very happy, yes, yeah. At least they can all watch you live and they can know that you're not with anyone else, that you're actually doing productive work, so it's good. Anyways, I thought I'd make a little light of that. Welcome to meeting number 50, the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the House Order of February 13th, 2023, the committee is beginning its study on the subject matter of Bill C-39, an act to amend the Criminal Code, medical assistance in dying. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. I'd like to make a few comments for the benefit of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either Floor, English, or French. For those in the room, you can use the earpiece to select the desired channel. A reminder that all comments should be directed to the chair. For members in the room, just raise your hand, and those on Zoom who wish to speak, please use the raise hand function. I use little cue cards, so when you're down to 30 seconds, whether that's your statement or your questioning, I just put this up so I don't have to interrupt you. And when you're out of time, I raise the red out of time card, and I just ask you to wrap up. If you don't, then I will unfortunately have to interrupt you. Let's begin now our study of the subject matter of Bill C-39 Act of
Mr. Chairman, I would just like, because I don't remember hearing you mention that there are people on Zoom, so I would like to know if the sound tests have been positive.
Absolutely. Thank you for asking. I've confirmed with the clerk that sound tests were all positive. Okay. So let's begin now our study in the subject matter of Bill C-39, Act to amend the Criminal Code, medical assistance in dying. Please welcome with me the Honourable David Lametti, Minister of Justice and Attorney General of Canada, and I think along with him the following officials: Matthew Taylor, General Counsel and Director of Criminal Law Policy Section; Joanne Kleinberg, I think she's online, Acting General Counsel, and Miriam Wills, Counsel. So am I missing anybody? And then I think we have some, and from the Department of Health, we have Sharon Harper, Director General. Is Sharon here? Yeah, this side. Okay, yes. And Venetia Lawless, Manager, End of Life Care Unit via video conference, and Jackie Lemaire, Senior Policy Analyst, also by video conference. So welcome, and Mr. Lametti, I'll give you 10 minutes if that's suffice. Thank you.
Thank you, Mr. Chair, for the opportunity to speak to the committee on Bill C-39, and I thank all of you for the urgency you have shown in considering this important legislation. I would also like to thank officials from both Health Canada and from the Department of Justice who are here with me this evening. As you all are full well aware, this bill transcends different departments, and therefore it is critical that I have Health Canada's support here this evening in addition to the usual DOJ support. L'ancien projet de loi,
Former Bill C-7, an act to amend the Criminal Code, medical assistance in dying, expanded in March 21st eligibility for medical assistance in dying to people whose natural death was not reasonably foreseeable. It also excluded temporarily mental illness as the only factor for receiving medical assistance in dying. If no legislative changes are made, the exclusion will automatically drop by March 17th, 2023, and then that will be legal. Bill C-39 proposes to extend temporarily this exclusion until March 17th, 2024.
Safe assessment and provision of MAID in all circumstances where a mental illness forms the only basis of a request for MAID. An extension of the exclusion of MAID eligibility in these circumstances would ensure healthcare system readiness by, among other things, allowing more time for the dissemination and uptake of key resources by the medical and nursing communities, including MAID assessors and providers. It would also give the government more time to meaningfully consider the report of the Special Joint Committee on MAID, or AMAD, which is expected to table by Friday, February 17th. I'm confident that a temporary one-year extension will allow us to proceed in a measured and prudent way and will ensure that we get this right. As always, our government remains committed to ensuring that our law reflects Canadians' evolving needs, protects those who may be vulnerable, and supports autonomy and freedom of choice.
As I just explained, former Bill C-7 temporarily excluded access to MAID in cases where mental illness was the only factor. This temporary exclusion is based on the recognition that these cases are often complex and that more reflection is appropriate. Over the past 2 years, a great deal of work has been accomplished. The expert panel on medical assistance in dying and mental illness undertook an independent examination of protocols, directives, and safety measures recommended in the circumstances where mental illness was the only basis for a request for MAID. The final group of the panel was introduced to Parliament on May 13th, 2022. In its parliamentary study, the Special Joint Committee on MAID has also been looking at the criminal code provisions surrounding MAID and the application in various contexts, including mental illness. In June 2022, the committee published an interim report that summarized the testimony received. The witnesses included psychiatrists, other doctors, people living with mental illness, and various groups. We eagerly await the final committee of the Special Joint Committee, which should be tabled by February 17th.
For their hard and important work. MAID is a very personal and challenging subject. We are better for their careful study and advice. In addition to the work of the expert group and the Special Joint Committee over the past 2 years, the provinces, territories, and healthcare community have been working with Health Canada to ensure system readiness. They have developed resources to support MAID assessors and providers, including clinician education and training. They have developed the necessary policies and practice standards. The work is well underway. Some provinces would likely have been ready to begin offering MAID for mental illness to eligible and properly assessed patients on schedule in March 2023. But we heard from many that they were not quite ready, and an extra year will make sure that everyone is ready and well equipped to make MAID for mental illness available in a way that is prudent and safe. So I'm here to talk to you today about the urgent need to extend the exclusion of MAID for mental illness by 1 year. But I would be remiss if I did also not take this opportunity to address some misinformation about MAID that I've heard over the past few months. I want to reassure all Canadians and all of you around this table that Canada's MAID regime is safe. The system has extensive checks and balances to make sure that only eligible people who clearly and freely choose MAID can access it. In 2021, in response to the Superior Court decision in Truchon, former Bill C-7 expanded eligibility to receive MAID to people whose natural death was not reasonably foreseeable. To address the additional complexities of these kinds of cases, we created a separate, even more stringent set of procedural safeguards that must be satisfied before MAID can be provided. Some of these additional safeguards include a minimum 90-day period for assessing eligibility, during which careful consideration is given to the nature of the person's suffering and whether there is treatment or alternative means available to relieve that suffering. This safeguard effectively prohibits a practitioner from determining that a person is eligible to receive MAID in fewer than 90 days. Another additional safeguard is a requirement that one of the practitioners assessing eligibility for MAID has expertise in the underlying condition causing the person's suffering, or that they must consult with a practitioner who does have that requisite expertise. The assessing practitioners must also ensure that the person be informed of the alternative means available to address their suffering, such as counseling services, mental health and disability support services, community services, and palliative care. And it's not merely enough just to discuss treatment alternatives. They must ensure that the person who has been offered consultations with relevant professionals who provide those services or care. In addition, both practitioners must agree that the person gave serious consideration to treatment options and alternatives. MAID for mental illness poses even more complex challenges. That is why we need to take the time necessary to ensure that the healthcare system is completely ready before we expand eligibility for MAID to those whose sole underlying condition is a mental illness. We recognize that mental illness can cause the same level of suffering that physical illness does. We are aware that there are people who have been waiting to become eligible to receive MAID in March 2023, and we recognize that these people are suffering and will be disappointed by an extension of the ineligibility period. We empathize with these individuals. Nevertheless, I believe this extension is necessary to ensure the safe provision of MAID in all cases where a mental illness forms the basis for a request for MAID. We need this extension to ensure that we do not rush the expansion of eligibility and that we make any changes in a prudent and measured way. Our main priority is to ensure the safe provision of MAID, and I'm confident that courts would find this short extension to be constitutional. Le Canada a développé des lois.
Canada has developed legislation on MAID that provides support for people's independence and we believe that the measures in Bill C-39 will enable this to continue to be the case.
Time to get this right. A one-year extension will give more time to ensure that the healthcare system is ready and more time to meaningfully consider and act on the Special Joint Committee's recommendations. Merci, and I look forward to your questions.
Thank you, Mr. Lametti. Now we'll go to our first round of questions, beginning with Mr. Moore for 6 minutes.
Thank you, Chair. Minister, we're here today because 2 years ago you made a mistake that is offside with your caucus. We know that you voted against the first MAID bill because you didn't think it went far enough, which makes you an outlier in your caucus. You came to this committee and said that Bill C-7, an act to amend the criminal code for MAID, was constitutional. The Senate, the unelected Senate, amended it dramatically, created a brand new bill, I would argue, saying that those who are suffering from mental illness would be eligible for MAID. This extension is evidence that you got it wrong 2 years ago. And I know that you're a professor, but you're not the only professor. I have a letter here signed by 32 law professors, and it says, "We disagree as law professors that providing access to MAID for persons whose sole underlying medical condition is mental illness is constitutionally required, and that Carter v. Canada created or confirmed a constitutional right to suicide, as Minister Lametti has repeatedly stated. Our Supreme Court has never confirmed that there is a broad constitutional right to obtain help with suicide via healthcare provider ending of life." So, Minister, quickly, who's right, you or these 32 law professors?
Thank you, Mr. Moore, for the question. I think I'm right, quite frankly.
Of course you do.
I believe that we got it right with our initial bill, Bill C-7 in 2021. What I felt we needed at the time with respect to mental illness was more time. And at that time, I believe I was right initially to say we needed more time. We accepted the parliamentary process for what it was, and the Senate added the category of mental illness as a sole underlying criterion. And we added a time period in order to do the work. Now, that work has, we feel, for the most part been done. But we were slowed by, in particular, the COVID pandemic, and it prevented all of the necessary work we felt from being done. At the federal level, we feel we've done most of it. I know that Minister Duclos and others feel that a great deal of work has been done. The chair of the expert committee, Dr. Gupta, feels we were ready to go.
Thank you,
and a number
Minister.
of clinicians.
I have limited time.
I think we have a sound position now. And I do believe that there is
Okay.
a very strong Section 7 argument to say that we need to provide
Minister, I
this
only have
right to
6
people.
minutes, so I gave you time to answer. Look, I wish I could say it surprises me that you think you are right and these 32 law professors say you're wrong. They say in this letter you're wrong. You just indicated, Minister, that there's some kind of constitutional requirement that we do this. But 2 years ago, you came to this committee with what's called a charter statement. You, as the Minister of Justice and Attorney General, have to certify that all government legislation is charter compliant. Your own charter analysis, speaking about mental illness, saying it is based on the inherent risk and complexity that the availability of MAID would present for individuals who suffer solely from mental illness. First, evidence suggests that screening for decision-making capacity is particularly difficult and subject to a high degree of error in relation to persons who suffer from a mental illness serious enough to ground a request for MAID. Second, mental illness is generally less predictable than physical illness in terms of the course the illness will take over time. Finally, recent experience in the few countries that permit MAID for people whose sole medical condition is a mental illness, Belgium, Netherlands, and Luxembourg, has raised concerns. The concerns relate to both the increased numbers of these cases and the wide range of mental illnesses in respect of which MAID has provided. So, this isn't the 32 professors talking. This is you. This is your charter statement. So who are we to believe? The Minister Lametti that sat in that exact chair 2 years ago with this charter statement, or the minister that's here before us today saying that somehow this is constitutionally required? And have you updated your charter statement now that we have an entirely new bill which expands MAID in Canada to those suffering with mental illness?
Thank you, Mr. Moore, for your question. I will be depositing a charter statement with respect to this bill. I think the short answer is I was right in 2021 and I'm right now. A lot of work has been done since 2021. We've had an expert committee that has looked at this. They have evaluated the safeguards and they have evaluated clinical practice. And they have produced a set of guidelines. A great deal of work has been done with provinces and territories in this regard. So we're not in the same place we were in 2021. You will recall when a number of people asked me around this table in 2021, I said we simply needed more time with respect to mental illness. But the direction was always going to be that we would always get there, because I do feel, as I've said, and I think the direction of the courts is clear, even if it is true that Carter didn't explicitly state this. But the direction of the courts is clear that this is a
Minister,
Section 7 and Section 15 right.
I only have 30 seconds. What you just said and what all these law professors said, but I don't want Canadians to be misled, because yesterday in debate, your own caucus was saying there's a constitutional requirement. But you told us 2 years ago there was no constitutional requirement. You've adopted a radical amendment from an unelected Senate. You made it your own. And now you're saying you're going to bring in a charter statement. Isn't the charter statement supposed to precede the bill? We should have that charter statement now. Your charter statement says that extending MAID for mental illness is wrong. That is the statement that you deposited with this committee. So who's right, you or you?
That statement was 2 years ago.
Very briefly.
We have, as I said 2 years ago, we thought this was inevitable, extending MAID for mental illness as a sole criterion, and that it would be something that the courts would find as a constitutional right that Canadians had, but we needed more time. We've now taken that time. We have done a great deal of work in 2 years. And we will deposit a charter statement within the usual norms for the tabling of a bill, as we are doing right now.
Thank you, Mr. Moore. Well, next, we'll go for 6 minutes to Madame Briard.
Thank you, Mr. Chairman, and good evening, everyone. Thank you, Minister, for spending this evening with us. You mentioned needing more time. Can you explain how this extension will give enough time to meet the government's objectives in preparing the health system? Thank you, Ms. Briere, for that question. As I just said, we have done a lot of work. We've had the expert group. We've got the special joint committee. They have done a great deal of work. The government, Health Canada, with experts, doctors, and nurses. Many people have worked hard. We are almost there. But to make sure that everyone is on the same, up to speed, we need to provide another year so that assessors and others are prepared to assess requests for medical assistance in dying in a coherent way. So we need to provide the time necessary to enable the guidelines and oversight to be understood by everyone. We are on the right path. There are a number of experts that think we are already there and we should just go ahead now. But we want to be careful and prudent, so we want to take another year so that we can all be on the same page. Thank you. Why, in your opinion, was it necessary to consult experts in the medical community on this complex issue? It is very complex and very personal. They are the professionals that work with those who are reflecting on this, the practitioners who work with the patients that would ask for medical assistance in dying in this context. These are the people who know their patients and working with the patients who know themselves better than anyone else does, and working with the practitioners. They need to work together to be able to assess the various options, and we are almost to the end of that process, but we do need a little more time to make sure that the system works well. Well, we do hope that people that will providing access to MAID for those whose sole underlying condition is a mental illness make a distinction between people with suicidal ideation and MAID. So what is the government doing to improve the mental health services and support for those suffering from mental illness? As a government, we have recognized the challenge posed by mental illness, and a few years ago, starting in 2016, we started to invest. We invested $5 billion in 2016 to target mental illness and to provide better support for those suffering from mental illness. And we are continuing. We saw the agreement this morning with the provinces and the bilateral agreements that will be put in place after that will look at various challenges, including one that has been identified, which is mental illness, because we need more resources in the system. We will be working with the provinces and territories to make sure that the quality of support for those suffering from mental disorders will improve. That is what Canadians want us to do, and they want us to work together. So this is a priority for us as a government, and we are walking the talk.
Dans le système.
In the system as well, there are nonprofit organizations that can be very helpful that work with this population. What have you heard from them? I went to Sherbrooke with you, and we visited a group that works with those dealing with mental illness, and that group was disappointed that there would be an extension of time before the people they work with, that is, those with severe mental illness, so a delay before these people could have access to MAID by providing informed consent. They would have wished us to be able to go ahead now, and they were disappointed. But I said to them that we were going to do what needed to be done so that everyone was ready. But for that organization and for the patients, this is what we need to do.
Next, we'll go to Monsieur Thibault for 6 minutes.
Mr. Tekiu. 6 minutes is pretty short to deal with such a sensitive matter. You opened a door for me, Minister, and I'm going to walk through that door. I don't believe that what you have put in this legislation will do more to help those people with mental illness and for the next 10 years. We need to make a distinction between mental illness because practitioners have said that isn't a good term. We should talk about mental disorders instead. So we should use the terms that experts are using for these issues. What experts have told us through their report is that we need to have standards for practice in this area. A working group was created to establish practices for MAID. Now, who are the people on that working group? Thank you. I could provide the names on that list. And for those who are not part of the Special Joint Committee, I am prepared to provide a list. Professor Stephen Lucas gave us the list of names, and certainly I can provide it. So the names of the people, do you not have them here? This is obviously a question for Health Canada. No, that isn't my question. I want to know whether they're members of the MAID practitioners group that are on that task force. Well, that is a question for Health Canada. No, it's not a question for Health Canada. It's a question for those who are accompanying the minister so that we know whether in 1 year the work will be done so that by March 2024 we will be ready. I want to be able to answer people when they ask me what is being done, what progress is being made. I want to know whether the practitioners of MAID are included in this work. I know that they are involved in the training, but are they helping to establish the practices? Yes, you are correct. There are 2 other ministers working on this bill, the Minister of Health and the Minister responsible for mental health. There are officials from Health Canada here with me. This is a question that comes under the responsibility of the other 2 ministers, and I will commit to you, Mr. Tekiu, that I will provide you with that answer. Thank you. There are 2 recommendations that are key, and they are different from everything that is being done right now. And these are in the expert group report, recommendation 10 and 16. So recommendation 10 says that to be eligible, the assessment has to be carried out by 2 independent psychiatrists, that is, independent from the treating team. Is that being done? Will this 1-year delay give enough time to train people for this? Will we have the capacity? Because this will be a much more important safety measure than for usual cases. The committee made that recommendation saying that the existing legislation was already adequate. But it is something that the provinces could add depending on their capacity, if they are able to have 2 independent psychiatrists involved. But it would give the provinces time to review what is in the report, and we will be there to support them if necessary. And then we will see in the bilateral agreements the amounts that will be dedicated to mental health. Now, recommendation 16, we've got the oversight. We have the end-of-life study underway in Quebec in the National Assembly that looks at this issue. The expert group has said that we need to put something in place in real time. Now, they say initially that it would not be part of the assessment, but later it says that the oversight would support practitioners by providing direct and immediate feedback on their practice and ensure that legal standards are met. Do you believe that this will be made into a rule? The short answer is that this is something we need to develop with the provinces. It comes under provincial jurisdiction. In each case, we are prepared because the expert group asked us to work together and to exercise leadership. I don't know if my colleagues have something to add on this.
So it's up to the provinces and territories. The regulatory bodies will take that on. It's not up to the federal government to be able to dictate. However, we have seen some very good response so far from provinces and territories and regulatory bodies saying that they are looking forward to receiving the final copies and to either adapt or adopt versions of the practice standards.
Mais la recommandation 1 dit.
But recommendation 1 says that you should facilitate that. So are you going to be facilitating that? Are you aiming to achieve that objective?
Let them answer that in the second half when you come back to that. Thank you, Mr. Thireault and Mr. McGregor. Both of you, by the way, welcome to the committee. I forgot to welcome Mr. Thireault, so welcome, and welcome Mr. McGregor. So 6 minutes, the floor is yours.
Thank you very much, Mr. Chair. It's good to be back on the Justice Committee. I don't think it's been since the 42nd Parliament. But thank you, Minister Lametti, for being here today. I just want to go back to the C7 conversation that you had with Mr. Moore, because I was in the House serving with you at that time. We had the third reading of Bill C7 on December 10th of 2020. So the version that we sent to the Senate was in line with your charter statement. Mental disorder still would not have qualified for medical assistance in dying. The Senate went through the bill fairly quickly. They were able to get to their third reading vote by February 17th of 2021. So a little over 2 months, and they reported it back to us with that amendment. So I guess I just want to narrow down. So you're telling us that in that 2-month period, that's when you kind of converted your thoughts on this. I just want to know your thought process, because the version that we sent to the Senate you were fine with, but then when they sent it back, just in that space of 2 months, you had a conversion and accepted what they had done to the bill. And I do believe they inserted that amendment not at committee stage, but as at the report stage of the bill. It was done from the floor of the Senate.
Thank you for that question. The only thing that changed was the timing of when, right? I had always believed, as I have said to my honorable colleagues from the Conservative Party, that we would get to this point and that we were required to get to this point, that people with mental illness, mental disorders are suffering. People with mental disorders have the capacity to ask for medical assistance in dying, as any other Canadian did, and the courts would eventually force us there. So the only thing that changed is do we in 2021, as originally framed, do we put the committee work, do we not put it in the bill, do the expert work, committee work necessary to get it to a point, and then pass a law? Or do we accept the Senate's reversal of that, which is to say, we're going to put this in with a sunset clause in order to force ourselves to do the committee work within what one would argue is the same time period.
If I can just interject.
So the substance doesn't change. The substance didn't change in my view. I'd always thought we weren't ready in 2021. I think we're very close to being ready now. And with another year, we will be ready. And I'd always envisaged something like this time period in my head.
Okay, well, I mean, if I can just interject, I think that, but there's been a pattern here, and that's why it's caused so much consternation amongst different members of Parliament. I mean, you introduced Bill C7 before the statutory requirement of C14 had been met. There was a requirement in that bill for a statutory review of the legislation, but C7 came in. Our special joint committee on medical assistance in dying, I was a member in the 43rd Parliament. I was a member in this Parliament. It didn't get its work underway. It was interrupted by the election in 2021. So I can tell you, Minister, that working on that committee, we always felt under the gun having that sunset clause hanging over us. You know, it was always hanging over us, and that was a real issue. I do, however, want to change to the expert panel that was convened by your government. Now, the panel in its report did say that existing MAID eligibility criteria and safeguards buttressed by existing laws, standards, and practices in related areas of healthcare can provide an adequate structure for MAID MDSUMC, so long as they are interpreted appropriately to take into consideration the specificity of mental disorders. I want to know about that because, of course, in our existing criminal code, in order to meet all of the eligibility requirements in Section E, they have to give informed consent, and only after they have been informed of the means that are available. I just wanted to get your interpretation of that because being informed of something is one thing, but we know from many people who have testified that in many areas of Canada, some of these services just are not available or not available in a sufficient quantity. So do you think your government might approach a change in the criminal code to change that term informed, or are you quite satisfied with what the expert panel has provided you?
Well, we have been consistent, both in the law and in the expert, that being informed is a meaningful process. One has to be meaningfully informed. One has to assess the what one has been told, and have the capacity to do so. So all of those represent, we think, a very adequate set of safeguards. The question of the kinds of social services and social supports, palliative care, mental health supports, other supports, is a different question. It's one that our government's committed to. I think it's one that we probably share in terms of our own values, in terms of getting that better. I think that's something that provincial governments and the federal government need to do working together. In most cases, it's primarily provincial responsibility, but we need to work with provinces and territories with respect to leadership and resources in that regard. I think it's a separate question. I do think it needs to be improved in a variety of different places. I'm committed. I've been committed to that as a member of Parliament and as a cabinet minister. I remain committed to that, but it is a separate question.
Thank you, Mr. McGregor. We'll now go to our second round of questions, beginning with Mr. Brock for 5 minutes.
Chair, and welcome, Minister and Department officials. Thank you for your attendance. Minister, I want to go back to my colleague's questioning regarding the charter statement. I'm just taking a look at the requirements. December 13th, 2019, amendments to the Department of Justice Act came into force, creating a new duty on you to ensure a charter statement is tabled in Parliament for every government bill. Charter statements are a transparency measure intended to inform parliamentary and public debate on a bill and help increase awareness and understanding of the charter. I listened to your evidence. You said it will be deposited, I think as your words, are tabled. But you also know, Minister, that yesterday was set aside for all parliamentarians to debate this issue. And largely we heard from Conservative MPs, not much from the Liberal bench. But between yesterday and tomorrow, approximately 15 hours have been set aside for parliamentary debate with no charter statement for any parliamentarian to review in advance, to factor that type of analysis in their speech. You've denied the ability of parliamentarians to really reflect on the legality of this particular bill. So my question to you is very specific. What does depositing mean, and when can Canadians, but more importantly parliamentarians, expect to receive this and review it fully?
You will receive it very soon. It
When?
will be
When, Minister?
It will be tabled in the normal course of business, but you will have it soon.
When, please?
I can't give you a time.
It's under your control. You can provide me with a timeline. Talking next week, next month, next year? When can we receive it?
You will receive it very soon.
What does that mean?
Very soon is very soon. I think the words are clear.
You indicated that provinces need some time, that Canadians are adjusting to this particular reality. I'd like to get your thoughts, Minister, on the latest Angus Reid poll that had 61% of Canadians polled supportive of the MAID regime, yet only 31% did not agree that the health or mental health issue as a sole criteria ought to be included. So 3 out of 10 Canadians felt that that was permissible. Over 70% of Canadians polled disagree. Are you mindful of that, Minister?
I'm mindful of the cause of that. I mean, first of all, we are moving ahead because we feel that we will be compelled by the courts to move ahead, and so we're going to do this. We are going to do this prudently. But I'm also mindful of the misinformation that is out there, which frankly, I'll be honest, a number of people on your political side are peddling. They're saying that somebody will, and I've heard this in the House of Commons yesterday, that somebody will be able to go to their doctor, a young person, and say, I'm having suicidal thoughts, I would like MAID. That is clearly not the case. What we are talking about here, Mr. Brock, is a fraction of a fraction. Already the number of people on track to MAID, from the numbers we've seen, the numbers I saw were 500 out of 10,000. That's half of 1% on track 2. This will be a fraction of that. And my understanding from experts...
Thank you, Minister. Minister, thank you. No, Minister, thank you. I've got 1 minute left. Minister, thank you very much. Chair, I'm ceding my time to my colleague, Mr. Van Popta. Thank you.
You have 1 minute.
Good, thank you. Mr. Lametti, on November 2020, you appeared before a Senate committee and said this: we want to exclude mental illness as sole criterion. After conducting consultations across the country, I can tell you there is clearly no consensus. But today, sir, you're here promoting exactly the opposite, expanding MAID for mental disability. Canadians want to know why the Attorney General changed his mind, and is he likely to change his mind again in the next 12 months, given enough resistance?
Thank you, Mr. Van Popta, for the question, and I appreciate the sincerity with which you're asking it, and I commend you for that. I just want to say to Canadians and say to you that we have now done the work. What I had said in 2020 and 2019, I meant that our consultations had said there wasn't a consensus. I respected the parliamentary process and our dealings with the Senate, and instead of passing a law and then saying we'll move to mental illness as a criterion, we accepted the Senate's reversal of that to say we are going to put a time limit on it, otherwise it'll happen inevitably. Now, it forced us to do the work, and we did the work. And now I think there's a very strong consensus amongst particularly clinicians, people who work with people with mental disorders, that and have tried multiple ways to help people suffering from mental disorders, and in a number of cases say there's nothing left that we can do, and the person would like to seek MAID. So the timing of this and the work that has to be done hasn't changed. The sort of order in terms of legislative technique has changed, but the substance of what I had to say hasn't changed. We are in a much better place now, and I think we're ready to move forward.
Thank you. Thank you, Mr. Van Popta, and thank you, Mr. Lametti. Now we'll go to Ms. Diab for 5 minutes.
Thank you very much, Chair, and thank you, Minister. Thank you, officials, for being here. I just want to start off with saying a couple of things. I wasn't here 2 years ago, nor am I on the committee that was struck. But I will say that MAID is a deeply personal and complex choice that really does touch every person and every family. These are usually very difficult, painful situations in a person's life as well as their loved ones. So, and I can appreciate that Government of Canada needs to get this right as best as it can, and I don't believe there's any such thing as anything perfect, because we all know laws change, and that's the reason why we're here, and that's why we have parliamentarians in courts. Having said all of that, can you just clear up a couple of things, I guess? I just want to give you enough time on record. What are the current eligibility criteria for MAID? What happens if we don't pass and give this extension? Can you just tell me what the law of the land is and where we are today? And after that, where are the provinces in this?
If we don't pass this extension, let me start there. If we don't pass this extension, then next month, mental illness as the sole criterion for seeking MAID will be possible, and people will have to deal with that. Medical practitioners, many of whom feel they're ready, many provinces feel they're ready, they will move. In terms of the current eligibility for MAID generally, one has to be 18 years of age or older. The special committee is looking at the question of mature minors, but for now it is 18 years or older. Secondly, you'd have to be eligible for publicly funded healthcare services. You have to make a voluntary request that's not the result of external pressure from anybody, including family or others. You have to be able to give informed consent to receive MAID, and after having received all the information to make the decision. Have to have a serious and incurable illness, disease, or disability. You have to be in an advanced state of irreversible decline in capability and have enduring and intolerable suffering. If you're on track 2, you need to make the request in writing, signed by an independent witness. You need 2 independent practitioners to provide an assessment. One of those 2 people has to have an expertise in the area. You need to be told that you can withdraw your request in any case, and that assessment period in track 2 has to be at least 90 days.
So, I mean, as a previous legal practitioner, it sounds like obviously there's a number of criteria to go through. It's not something you can say, I want this, and you're going to get it tomorrow.
And in particular in the track 2, when it's a non-end-of-life scenario. That's a pretty stringent set of criteria.
So, can you comment on the procedural safeguards, and I think you did, to protect people who might be more vulnerable than others when requesting MAID?
Well, it was precisely the Track
Yeah.
2 that did that, and we did that after careful consultation with a number of different communities, including representatives of people living with disabilities. The 90-day assessment period was meant to be a sufficiently long period so that in the case of a catastrophic accident, someone would have time after that initial period to reflect about what happened and about what might be possible. There is a criterion, as I've mentioned, to be made aware of what the possible supports are and to have meaningfully thought about that with a practitioner and discussed those alternatives for support. There is, again, the criteria to have two assessments from people, and one of those people has to have an expertise in the field. With Mr. Terrio's previous question, we kept that flexible because in some places, such as the North, they felt that having two experts in a particular medical field, for example, might be an impediment. And so we made that flexible, but obviously it's it can be up to provinces to make that more stringent if they have the resources to do so.
So what are the provinces, if I have any more time?
Unfortunately, Ms. Diab, we
Okay,
are
thank
out
you
of
very
time.
much.
Thank you, Ms. Diab. Now for 2.5 minutes, the last round, Mr. Thibault, for 2.5 minutes.
C-14 was a terrible bill. It was a bad copy of the Quebec law that made it so that people, for a time, had to bear the burden of going before the courts, even if they were in wheelchairs, they didn't want to be infantilized, and they had enough discrimination in their lives. Other people had to stop eating or drinking so that they could cross the threshold of a foreseeable death. So C-14 was bad. C-7 improved things, and a compromise was that because the Senate decided that mental illness would not be could not be the sole underlying condition, then what we need to do is have experts involved. They told us not to talk about mental illness, but mental disorders. They made 19 recommendations, and I would invite you to read them. So 2 years ago, I was quite resistant. I read the report 20 times or more, and I do think that the prudent approach is to pass Bill C-39 to make sure that somebody who has been suffering for 30 years, who sometimes because of medication feel is in an inhumane situation. So even if someone who tried to commit suicide, then it would take decades under the current safeguards to use all of the possible treatments. So I am in favor of Bill C-39, but I am going to be watching you and all the others involved to make sure that we are all ready in 1 year. We weren't ready for this March. There are people out there who are just doing the training now. We need more trainers. We need more people for oversight. We need to avoid any mistakes. There are 2 strong recommendations, recommendations 10 and 16, that will help us put in place the necessary safeguards for MAID in the case of mental illness. So I don't have any questions. Thank you.
Shrian.
I agree with you completely. And of course, we will take into account your opinion on the recommendations. In fact, I share your opinion. We need more time, and this is why we've brought in this bill.
On to Mr. McGregor for 2.5 minutes.
Thank you, Mr. Chair. Minister, when I was on the Special Joint Committee, we heard from a lot of witnesses and very far-ranging topics. And I remember when it came to this specific subject matter that we're dealing with here with C-39, some of our witnesses did say that there aren't really any specific criteria for knowing that a mental illness is irremediable. And that there's not a lot of evidence out there that anyone can actually really reliably determine if an individual suffering from a mental illness will not improve. So that's how it's different from a physical illness, and that's what's given us a lot of pause. We just want to make sure that we are in fact getting this right, and I think that's why you're seeing a lot of this trepidation. I guess what I want to know from you is, I agree C-39 needs to be passed. We do need this extension. But given the testimony that we did receive in terms of irremediability of this, of mental disorders, and just still the unknowns that exist, when we are approaching March of 2024, I guess, how are you going to ensure that everything is in fact in place? And are you going to put in place plans for Parliament to have another say or another review of this before that deadline comes into effect in 2024?
My understanding with respect to the question of whether there's a remedy or not, irremediability, is that if that criterion can't be met, then a person's not eligible for MAID. And let me flip that around. If it is only in cases where it has been determined, and experts tell us this can be determined, where there is no remedy, and they are certain of it, then that person would be eligible for MAID. As Mr. Theriault has just said, this is for long-standing mental disorders treated by a psychiatrist, where everything has been tried, and where the person is capable adult, capable of making up their own minds, and there is no remedy. If that criterion can't be met, then my understanding of the way this works, that person would not be eligible for MAID. So this will not be many cases, but they will be important to those people who have been long suffering in those cases, and frankly, that's why we're here.
Thank you, Mr. McGregor. I want to thank the Honourable Minister Lametti for joining us today, and we thank you for that. We'll just suspend for a minute or so while he leaves. I think the officials will be staying, so to answer the rest of your questions. So I'll just suspend briefly. There won't be any statements, I guess, because the minister's already made it, so we'll go straight to a round of questions. We'll begin by Mr. Caputo for a first round of 6 minutes.
Thank you all for being here. I anticipate most of my questions will go to you, Mr. Taylor, although Ms. Kleinberg and Ms. Wills may jump in. Mr. Taylor, you're familiar with the charter statement of October 21, 2020, correct? Okay. You stood by that statement as of the date it was published, correct?
I don't know what you mean by stood by, but certainly that is the charter statement that explains the impacts, the charter considerations relevant to the bill as it was when it was introduced.
Okay, what I'm saying is that when I say stood by, you agree that this is an appropriate statement, correct?
Yeah, that is
And
the statement.
it accurately reflected the law, correct? Yep. Okay. Now, October 2021, 2020 isn't very long ago, and you'd agree that the law, as it was reflected and discussed in this charter statement, has changed substantially in a little over 2 years. You'd agree with that, correct?
The law has changed
Pardon me, the
substantially.
proposed legislation.
Well, certainly the legislation before you today is different than the legislation that was the basis of the charter statement for C7. Certainly the charter statement for C7 doesn't speak to the mental illness exclusion that was enacted by the Senate.
Well, I'm going to stop you there, sir, because I think it does speak to that. I'm going to quote you, in fact, and say, looking at, what's a few pages in here, and I quote, "Rather, it is based on the inherent risks and complexity that the availability of MAID would present for individuals who suffer solely from mental illness." And I could go on, but it talks about, quote, "subject to a high degree of error," end quote. That's right in the charter statement. You'd agree with that, correct?
Correct.
And you would therefore agree that this does discuss the very thing that is that we're contemplating here, that Senate amendment. You'd agree with that?
It discusses what was in the bill as the bill was introduced. It discusses the effects of that legislation vis-a-vis charter rights of individuals in Canada under Section 7 and Section 15, I think, specifically. So speaking to the absence of eligibility for mental illness in that case.
the reality is this: in 2 short years, we went from a charter statement saying there are inherent risks to MAID for people with mental illness, to the minister standing here, sitting here, less than 2.5 years later, saying, "Well, no, there aren't no inherent risks because we can move forward." You acknowledge that change, correct?
I think the minister said that he appreciates that there are risks, and I think the charter statement in C7 reflects that. I think what he also said was that a period of time was needed to work through those risks, and that more time is needed. He spoke to the work that's being done with the provinces and territories to address some of those risks, and he spoke to the need to spend more time to address those risks.
But see, here's the problem, though, sir, is that when we talk about risks, nobody's saying what risks mean. In this statement here, the charter statement actually outlines the risks. You'd agree with that, right? As in high degree of screening for decision-making is particularly difficult and high degree of error. That is a tangible risk. You'd agree with that?
Yes.
Okay. So when we talk about risks, as you've just talked about with what the minister says, we're not talking about something tangible that we can say, well, these are risks. We're just talking in generalities, correct?
I'm not sure I understand your question.
Well, the point is this charter statement says there are risks. And from what I'm hearing from you and from the minister saying, well, yeah, but we're going to deal with those risks. But what are the risks that are going to be dealt with in this legislation? That's my point in the intervening period.
Well, this legislation doesn't change, if enacted, I should say, wouldn't change the current state of the law. It would if it is enacted prior to March 17th. So the current state of law would remain.
In 1 year, though, we revert back, and people with mental illness will be able to access MAID, correct?
In the absence of another something happening. And I should just also note that the federal legislation, the federal sphere, speaks to the criminal law framework governing, so exceptions to criminal liability. The provinces and territories are still responsible under their authority for health care to assess what criteria, what safeguards, what policies, measures need to be put in place should medical assistance in dying be offered in their jurisdictions where mental illness is the sole medical condition.
I only have 1 minute, so I'm going to ask you this. We have here, screening for decision-making capacity is particularly difficult and subject to a high degree of error. Those risks still exist today and will still exist a year from now, will they not?
I can't answer that question. I'm not a medical professional. I can't speak to that.
Well, it says it right here in the charter statement.
Yes, it does.
So this is a legal document saying these risks exist. So can we now say that these risks may not exist when they're here in the charter statement, the very charter basis on which we are to rely on passing this legislation? Do you see the tension there?
I get the tension. I understand the seriousness by which you as parliamentarians are considering this issue. I think we're well aware of the concerns that have been expressed by stakeholders.
Here's my last question, sir. These risks have not yet been addressed. That clearly, that's what I can deduce. You'd agree with that. We have no basis on which to conclude that these risks have been addressed, do we?
I think I would say that those risks are being addressed currently and have been over the last 2 years in terms of the work that the federal government has been doing with the provinces and territories.
High degree of error in relation to decision making. That is an on-the-ground issue. That's saying that people can't make this done, that can't do this properly. That's not something that can be ameliorated, sir, with all due respect.
Thank you, Mr. Caputo. We'll now go to Ms. Dillon for 6 minutes.
Thank you, Mr. Chair. Good evening. Thank you to our witnesses for being here. Mr. Taylor, would you like to conclude any of your thoughts to the previous question?
No, I mean, the only other thing I would remind the committee of, and I know the committee is seized of this, is that a charter statement will be provided in a very short timeline, very soon, as the minister has said, and that will provide additional information on the charter considerations around this legislation. Thank you.
Perfect. Thank you for that. And how is the current MAID oversight regime operating?
I might ask our colleagues at Health Canada to answer that. Thank you.
No
problem. MAID oversight is, in fact, something that our MAID the federal government does MAID monitoring, and we do that through collecting data about MAID and providing annual reports. And so that's how we do the MAID monitoring. The oversight of the implementation of MAID is at the provincial and territorial level, and they do that in a number of different ways. Being with the provinces and territories, they take different approaches to that. Some of them, like Ontario and Quebec, they review every single provision of MAID that has happened. They review it and they oversee that. Others take different approaches to doing that. And so, and one thing that we are doing with them is we are providing leadership in terms of talking about oversight and encouraging quality assurance and more oversight in terms of how MAID has been provided. There are also informal methods of oversight that happen as well. So there's case conferences among professionals. So they talk about how MAID takes place. And there's also discussions with the Canadian Medical Protective Association and CAMAP as well to make sure that the practice is safe and works according to established measures.
And could you tell us a little bit or elaborate on how the Government of Canada is engaging with provinces and territories?
Yes, we have a very long-standing working group with the provinces and territories. It's been around since 2016, and we've worked very closely with them throughout the years to help work with the interface between the criminal law and the implementation of medical assistance in dying. And we continue to work with them at this point, and we plan in the coming weeks and months to discuss with them various issues that have come up in the expert panel's report and to understand how they see their systems responding to those recommendations.
Thank you so much. And if you could talk to us a little bit about how families and those with mental illness and their families are made a part of the discussion.
Made a part of the discussion?
Yes, how can they be a part of these discussions? Or if anyone else can.
Sorry, they made part of the discussion. I think that the Federal Provincial Territorial Working Group is basically a group that works together to consider how MAID can be implemented in the provinces and territories based on the criminal law that exists at the federal level. I think that families and people and individuals can be involved in the sense with practitioners. And I think that during the assessment period, especially in Track 2 cases, they are encouraged to consider talking, to find out as much information as they can about the individual to understand what is resulting in the request for MAID.
Okay. And can you tell us a little bit why it was also important to consult medical experts and members of the medical community when it came to this issue?
Definitely very important to understand that because the medical community has been working on MAID cases since 2016 and also working with complex cases since 2021. And so cases where what we call Track 2 cases, but this is where reasonable death is not reasonably foreseeable. So they understand very well the complexities that are being brought forward by these cases, and we really needed them to weigh in, for example, on the clinical practice standards. So they were sent out to a wide range of people to get feedback on those standards, and they're being incorporated now, that feedback, and they will be ready by March 2023.
Thank you. Am I out of time?
30 seconds.
Would you be able to quickly tell us how the Government of Canada is putting in place ways to improve mental health supports?
Certainly. There are a number of different approaches that the federal government is taking to mental health supports. I would One of the things that's quite relevant to what we're talking about today is a suicide hotline, and that is very relevant to the work that we're doing. There is also Wellness Together Canada, which has been put in place to help support Canadians and healthcare providers in their efforts to improve their mental wellness. So I think those are two very important pieces.
Thank you, Ms. Dillon. Next, we'll go to Mr. Thiroux for 6 minutes.
Merci, monsieur.
Thank you, Mr. Chairman. Human beings who are dealing with a mental disorder that has become chronic will have dealt with stigmatization throughout their life and discrimination as well, so that even someone who is born in a very comfortable situation is likely to become poor at the end of their life, because when we are talking about severe and chronic mental disorders, people aren't usually able to hold a job. They're often unemployed. And some people would say, well, that's the case. There's nothing to be done. We have to discriminate against them and not necessarily let them to make a decision until they get to an intolerable situation. Legal experts would say that if the state decided to completely exclude people with chronic mental disorders for whom there is no treatment, that this would be discrimination under Section 1 of the Charter. What would you have to say to that?
Est-ce que
Will I have the extra time? I think that the witness didn't understand the question. Well, you could hear the interpretation if you didn't follow. I think I understand the question.
There are diverse views on these issues. Minister Lametti has expressed his views on the charter and its relationship to cases where mental illness is the sole medical condition. Some of the committee members have spoken to the letter from the law professors who have expressed different views. So there are a diversity of views on that. What I would say, and I know it's not a complete answer, is that the charter statement that will be deposited by the department will provide some information on the effects of this legislation on the charter rights of individuals.
quand on parle d'un risque,
When we talk about high risk, the experts from the experts panel did not overlook that. They said yes, and therefore there shouldn't be general universal rules, that there needed to be a case-by-case approach. Each case needed to be studied separately to see how the disorder developed and progressed, to see the various types of treatment, and then ensure that the assessor was not part of the care team, and that there should be a practitioner who was not part of the care team and an independent psychiatrist as well. So yes, there is high risk, and if we take precautions, and put in place safeguards, then we will do this properly. If nobody has doubts that mental disorder is more difficult to assess. That's why we created the experts group and then had a special joint committee. I think that now there is an appreciation by the state of what this higher risk really entails. What do you think? So that this has been taken into account now.
Est-ce que je pose des questions en chinois?
Am I asking questions in Chinese?
Je pense que c'est
I think that
J'ai
mon
aucun
collègue,
problème.
Ms. Harper va répondre à vous, Monsieur Thériault.
Yes, I think that you are very correct in terms of how the risks will be addressed through a very a case-by-case understanding of the individual and bringing to the situation all the different social determinants of health and all the different things that can be made available to the person to help address the risk, and also seeking out experts who can also bring their expertise to the question. Does that speak to your question?
30 seconds. Je vais faire une question plus simple.
I'll ask a simpler question. You are legal experts as well. Do you think that excluding people with severe chronic mental disorders is discriminatory?
Ce n'est pas mon place de...
It is not up to me to answer that question.
Ben, on vous a pas invité au comité.
Well, you weren't invited to the committee. Well, I think that's a good decision.
Thank you, Mr. McGregor, for 6 minutes.
Thank you, Chair. Mr. Taylor, maybe I'll start with you if I can. I did ask the minister in the first round about the section where, someone has to be informed of the means available to relieve their suffering, including the appropriate counseling services, mental health and disability support services, community services. This is all under Section G for Track 2, because I think we can rightly determine that for those who are suffering with a mental disorder and they're going through that profound internal psychological suffering, their death is not going to be reasonably foreseeable. So they have to come under the safeguards specified under Track 2. I guess my question to you is, the criminal code uses verbs like informed and uses the verb has been offered. Is that the limit of what criminal law in Canada can do? And what is the federal government's expectation on the provincial side of things for how their medical systems will step up to ensure? Because I can tell you, just from my own personal experience as a member of Parliament, I know in my community, I represent a riding on Vancouver Island, we do have a lot of people who are going through extreme mental health issues. There's a lot of underlying trauma. It is feeding a lot of the opioids crisis. And I understand there are additional safeguards, like someone's not just going to be able to walk off the street and access MAID. I understand that very clearly. But I'm just trying to figure out where the language of the criminal code, the necessity of being informed and offered meets the provincial side of things. If you could just sort of walk us through that.
I mean, I can start on the federal criminal law side, and maybe my colleagues from Health Canada can jump in terms of what they might know in terms of how this provision is being operationalized. I think Mr. McGregor, as a general matter, words in statutes are meant to be interpreted in their ordinary meaning. So, the use of the words like informed or offered are there every day. There's no kind of technical legal meaning to those terms. So informed, made aware, provided the information, offered, similarly, have been given the information about. Sure.
When they come under a section labeled safeguards,
Yes.
they do take on a little bit more importance, wouldn't you say?
Certainly, in terms of the way they operate in the statute, they have a specific purpose, and you're right, it is related to the safeguards. So these are important. I maybe will turn to Ms. Harper if she has any information in terms of how it's actually being implemented.
Well, I think that one of the things that we can look at is that PTs are looking at how to set these up so that these complex cases can be dealt with appropriately. So some PTs have been exploring the creation of panels or committees to support assessments and case review. Others are planning for teams to assist with undertaking complex assessments. So, and facilitating consults with clinicians who have the necessary expertise, or making referrals to treatments and services. So they're trying to bring together the resources that they have to the requirements of the criminal code.
Sorry, I just want to make sure I've got time for a question, because you mentioned treatments and therapies. I think those were the two terms. I met with some patients today, and we've heard testimony of the Special Joint Committee about alternative therapy, such as guided psilocybin therapy that is being used. There's some promise. I will acknowledge that the research, there's a lot more that's needed, so that's the caveat I'll put out there. That being said, though, it has shown some promise in both helping people in palliative care relieve the existential dread that they feel knowing their end of life is coming. But there's also perhaps some promise in maybe effectively treating mental disorders. And I know from conversations with them that either through the Section 56 exemption or the Special Access Program, there's still a lot of trouble they have to go through to get approved. So I'm just wondering, what is Health Canada doing with respect to these types of alternative therapies? You must be aware of them. Is there additional funding and research coming our way to fully explore this? Because we're dealing with a pretty monumental shift to our criminal code here. And we just want to make sure that all of the alternative therapies, if they do show promise, are available and are being explored to their full potential.
Thank you very much for that question. And you are quite right that there are a number of burgeoning therapies out there, and people that are saying that this has really helped them in a lot of ways. Unfortunately, today I do not have the information with me, but we can commit to getting you some information about that.
Okay, I would appreciate that. Thank you very much. Chair, I'll leave it there. Thank you.
Thank you, Mr. McGregor. We'll next go to a round of 5 minutes for beginning with Mr. Van Popta.
Good. Okay. Thank you, Chair. Thank you, witnesses, for being here. Mr. Taylor, I'll start with you. After having heard Mr. Lametti give his earlier testimony, I just want to confirm a few things with you. First of all, I want to confirm that no Canadian court has ruled that excluding mental disability from MAID is unconstitutional. No court is telling us that we must do it.
To my knowledge, no court has.
Good, thank you. This is strictly a political initiative started by the Senate and now being promoted by the government. It's not a legal initiative at this point.
Well, it is a legal initiative insofar as there's a bill before Parliament, and certainly Parliament enacted former Bill C-7.
Yeah, fair enough. Good, thank you. I also want to confirm that that C-7 was initiated after the Truchon decision, which was a lower court decision, and that the Attorney General decided or neglected or did not appeal to the Quebec Court of Appeal and, if necessary, to the Supreme Court of Canada.
Correct. There was no appeal.
Good. Okay. Thank you. One other thing I want to confirm, and that is that there is, my colleague talked about this already, there is no charter assessment having been done on the new and expanded C7?
There's no charter statement yet tabled in Parliament with respect to Bill C-39. But if your question was there a charter assessment done of Bill C-7 as amended by the Senate? And if that was your question, as you likely know, charter statements are not evergreen documents, so they're a reflection of the charter considerations of a bill as the bill was introduced. But
So the bill was initially introduced, or the charter statement rather is dated October 2020, and Bill C7, the way it came back revised from the Senate, was passed about a year later, and there was no intervening charter statement.
correct, because they're not evergreen documents.
Right. So when Mr. Lametti said, in response to a question from my colleague, when will we see the revised statement, he said in due course. Well, due course would have been 2 years ago.
Well, a charter statement is required under the Department of Justice Act for any legislation that's introduced in Parliament. And as you know, C-39 was recently introduced, and thus a charter statement will be tabled.
Right. I just want to confirm that there was no charter statement in connection with the revised C7, the way it came back from the Senate.
Correct. As I've said, there's no requirement to update charter statements in the Department of Justice Act to reflect changes passed by Parliament.
Even though there was a very, very substantial change.
Regardless of the amendments, there's no requirement.
Okay, good, thank you.
Yep.
Thank you for that. I'm going to turn over to the Health Department officials. So C7 was passed 2 years ago, and it requires, it allows that medical disability will be included for MAID provision, but there was a 2-year suspension. And in that 2 years, we were to come up with safety guidelines and regulations. What is the status of that? And I'm going to just refer quickly to a letter from the Minister of Health dated October 22, 2022, so just a few months ago, to the special committee. And in it, he says, quote, by March 2023, we expect that there will be practice standards and training modules in place. We haven't seen those yet, and now we're facing a year delay, presumably because those practice standards and training modules are not yet in place. Could you comment on that?
Certainly. The practice standards, actually, we expect them to be in place in March 2023. At this point, they are incorporating the feedback that they got from a number of people and a number of regulatory bodies and clinicians across the country. They're incorporating that feedback, and they will be ready by March 2023, at which point there will be a broad dissemination approach for the practice standards.
Good, thank you. So in his statement earlier, the minister said that he expects that he is fully confident that in the next 12 months, we will be completely ready for medical assistance in dying for people with mental disability. I wanted to put this question to him. He's not here, so I'm going to put it to you. And I don't mean it in any sort of political or partisan way, but how will we know that we are, in his words, completely ready when there is so much resistance from the medical profession?
Very briefly, please. Thank you. Well, I'll give you time.
I'm sorry, I didn't hear what you said.
I was going to say very briefly, but it's a very deep question, so I will be liberal with my time.
Rather than
Thank you.
conservative. How will we know that we're completely ready?
I think that that is a good question. I think that we will have a very good sense when the clinicians feel that they are well supported and that they have the resources that they need to make the assessments, and that they can that they understand what they need to do in order to make the assessments for people with mental illness as a sole underlying condition. I think that's a really crucial step. Now, it will take time because they will need to, with the clinical practice standards, I think they will be able to take those up The provinces and territories and the regulators will be able to adopt and adapt those, and then the providers will be able to take them on and will be able to try them in various situations. And what the interesting thing is, because the expert panel said that the practice said that the cases of mental illness were not in some ways that different than other Track 2 cases. They will also be able to bring these clinical practice standards to questions of cases that they're working with right now. So I think that that's going to be a really instructive year, that they will be able to bring those clinical practice standards and be able to understand how to bring them to life.
Thank you. Thank you, Mr. Van Popta. And next we'll go to Madame Briard for 5 minutes.
Thank you, Mr. Chair. I will ask my question in French. Monsieur Taylor, est-ce que...
Mr. Taylor, is it possible to know whether something is constitutional or not without a decision from the court?
Je peux répondre en anglais?
I will answer in English.
I mean, I think you're right. Ultimately, at the end of the day, in our system of law, it is the courts who will decide in a constitutional democracy whether something is or is not constitutional. So certainly, as we know, there are different perspectives on all areas of law and charter compliance with those areas of law, but ultimately it is the courts who are responsible for making those final determinations.
Thank you. On veut...
We want to proceed properly and protect the most vulnerable, but protect the freedom of choice. We have heard a lot of disinformation. What do you answer to those that associate suicide with medical assistance in dying?
We agree that there needs to be, that is a very difficult question, but we recognize that suicidality is a concern and agree that it's important to distinguish between suicidal intent and a rational and well-considered request for aid from someone with a long-standing mental disorder. So we've heard from practitioners that psychiatrists are well-trained to do this. They have indicated that suicide assessments are already part of the current MAID assessment practices, as are suicide prevention efforts when these are warranted. Now, the expert panel has made recommendations to assist practitioners in discerning a rational request for MAID, including doing many assessments over a period of time, including, when possible, during periods of remission or reduced symptoms, and not during periods of acute emotional distress or crisis. The panel advises that suicidal ideation must be considered and evaluated to best determine whether the requester's wish to end their life by MAID represents a capable appraisal of their situation rather than a potentially treatable symptom of their mental disorder. And now the MAID practice standards, which will be available in March 2023, will assist in this regard.
Merci.
Thank you. Because we have heard in the special committee from a psychiatrist who was from Ontario, I believe, and said that throughout their career, 30 years or so, she provided MAID to 2 people who had as a sole underlying condition a mental disorder. Do you have an idea of how much demand there might be for MAID in these contexts?
Est-ce que je peux parler en anglais?
Could I answer in English?
We actually expect the demand to be quite low based on international comparisons. And right now, we, over the last year in 2021, we've been able to determine that of all the MAID provision that there was, what we call Track 2 cases, it was only 2.2% of those which were cases where reasonable foreseeable death was not reasonably foreseeable. Now, we expect, based on, I think it was Belgium, or was it the Netherlands? The Netherlands. It was 1.5% of the cases, the assisted dying cases in the Netherlands, are actually those based on psychiatric conditions. So we expect something similar with respect to our MAID law in terms of Track 2 cases.
Est-ce que vous tenez compte?
Do you take into account the demand that there has been in Quebec, for example, where demand has been perhaps higher than expected? So do you take that into account? Do you look at the breakdown by province?
Yes, in our monitoring reports, we do break down all the information by province and territory, and in fact, it's a quite extensive report. Right now, it would not look at MAID for in cases of mental illness because, of course, it's not yet legal. But of course, this year it will look at all of the Track 2 cases over a full year, and I think that there will be quite a bit of information in that report that will be very useful.
Thank you.
Thank you.
Thank you, Ms. Briard. Last, we'll go to 2.5-minute rounds. We'll make them 3 minutes. Mr. Thibault for 3 minutes.
Merci.
Thank you. We talked about vulnerability. Who can be more vulnerable than somebody with an incurable illness and is beyond his level of tolerance? So when we talk about vulnerability, this is why I think that the government is being judicious in not going to the Supreme Court when people were almost starving themselves to death because they could no longer stand the suffering in order to get MAID. It was the court decision that was criticized by my colleague. The judge said that we are putting people's lives in danger because instead of helping these people when they have risked their level of tolerance, we are forcing them to suffer more. So what we are saying is the only escape is through suicide. And these people should have had to go right to the Supreme Court when they were already suffering intolerably. I think that isn't the state's role. The state should put in place the proper conditions in order to allow for free will. So there have been no court decisions that have really done anything but force the government to act. We've had C7, C14, Ms. Gladue and Mr. Truchon would never have had access if they hadn't gone to court. So that's what forced the government to bring in C7. We really need to look at who are indeed the most vulnerable people, and I think those are the ones who are suffering incurably, and because we think we as the state know better than them. No, they don't have a right to MAID, but I would like to know why that is the case. We need to have free and informed consent, but if the state says that there cannot be any help at this most intimate time, that the government should decide. I am afraid I can't agree with that, and so I do believe that we should go ahead with this, but we have to be careful to be well prepared because there are people with mental disorders, and it's difficult to put all of this in place properly across the country. There might be resistance. There are institutions in Quebec, for example, who don't want to provide MAID even when people are close to death, even though there is consensus that this should be allowed, and that's a scandal. We shouldn't allow that.
Very briefly, please. It's more of a statement.
J'en attendais pas un, mais...
Je pense que si le ministre était ici, il serait en accord avec vos commentaires.
I think if the minister was here, he would be in agreement with you.
Thank you. Mr. McGregor for 3 minutes.
Thank you, Mr. Chair. You know, our special joint committee, we did release an interim report specifically on this subject. It was tabled last year. And I'll just quote from our conclusions, quote, "We must have standards of practice, clear guidelines, adequate training for practitioners, comprehensive patient assessments, and meaningful oversight in place for the case of medical assistance in dying where a mental disorder is the sole underlying medical condition. This task will require the efforts and collaboration of regulators, professional associations, institutional committees, and all levels of government, and these actors need to be engaged and supported in this important work. Although some work is already underway to implement the recommendations of the expert panel, there is concern that more remains to be done to ensure that all necessary steps have been taken to be ready by the March 2023 deadline." Now, you've expressed confidence that I was writing notes that by next March, the standards will be in place. I know that provincial governments and the regulatory bodies are already talking about this, and I guess what I want to know, one question I have is, in Health Canada's conversations with your provincial counterparts, do you expect that the provincial governments and the regulatory bodies, the professional associations, are they going to 100% accept these, or do you expect in some provinces there might be some variances here and there? That's what I'm curious about. I mean, I expect they all have very much a vested interest in the work that's been done so far, and I know a lot of very committed people are working on this, but do you get a sense that there might be the odd little bit of variance depending on what province you're in? And now they have an extra year to think about it.
That's a good point. In a country with 13 different provinces and territories, I expect that there will be some variation because they're very interested in the practice standards. We had an excellent response when they were sent out for consultation and for feedback. And some of them have committed to adopting them wholesale, just taking them on. I think that others, what we like to use is adopt or adapt. So they will look at them, certainly. I think they will all look at them very carefully and see how they fit in with the processes that they currently have, and adopt those that they feel will strengthen their current systems. So I think that that's how the provinces and territories will probably look at them, but they are quite enthusiastic to see these and to be able to use them and bring them into their own systems.
And to be clear, just 1 second, Chair, I mean, the criminal code, the safeguards, that applies nationwide, of course, exactly. But we're talking more that the specific provincial jurisdiction that they have in the regulatory bodies, just to be clear, right? Yeah.
Exactly. This is how they build their system in relation to the criminal codes. The criminal code stays the same, and then they take medical practice, and they work with that and their jurisdiction around medical practice to make the system, the implementation of it, if you will.
Thank you, Mr. McGregor. I want to thank Ms. Harper, Ms. Lawless, Mr. Taylor, and Ms. Wills for attending this this meeting, this special meeting, and I want to thank you and hope you have all a great evening. Oh, yes, and Ms. Kindberg and Ms. Lemaire. Sorry, I should have looked right in front of me. Take care. The meeting is now adjourned.